Hi and hello, and thank you so much for tuning in. And if you are new, welcome to my channel. My name is Preeti Rao and I am both a real estate and a mortgage broker for close to 20 years. Now, I recently met with a lawyer friend and had quite an interesting conversation about an article that came out in the Toronto Star a few weeks ago, which asked a very pertinent question. When do defects have to be disclosed in a sale of a home? If you ask the seller, they have a different opinion. If you ask a listing agent, they say otherwise. But a lawyer, oh boy, they have the right answer. So let's break it down. But first, you know the drill. Please hit the like, share, subscribe button and that bell icon. It gets me motivated to keep you up to date with everything real estate. Did you know how many buyers went through so much trouble back in the day when bidding wars were going on and where the buyers had really no choice but to give firm offers irrespective of the state of the home? They liked it, it was within their budget, sometimes a little higher, but they bought it. No inspection. And even if they did the inspection before putting an offer, they could not go to the seller and say, you know what, fix this. You want it, you buy it. You fix it. It was that bad. Once the deal closed, and if then the buyer went and did the inspection and found some damage to the house, again, it was their problem. So not only did the buyers have to overpay for a home, but if there was something wrong, that also then became their problem to fix. Now mind you, I am not talking about defects that are noticeable here. We call them patent defects, like cracks in the wall or a broken window or even a stain on the wall because of a leaky roof. That we can actually see. Today, I'm only talking about the latent defects, the defects that cannot be noticed or detected by reasonable means. One classic example of a latent defect is a foundation crack hidden behind the walls of a finished basement, which is impossible to spot during an inspection. It's a tricky situation, and the whole point is the onus falls on whose head? According to OREA, it's the seller's responsibility, and because they live in the home, they should know what's going on in the house inside and out. Now, for those who don't know, OREA is the Ontario Real Estate Association. They publish and distribute the standard forms used by real estate agents throughout the province. And earlier this year, they introduced the Form 299, Seller's Disclosure Latent Defects. The problem is, this form is so completely wrong that it is bound to get agents, buyers, and sellers who use it entangled in a needless litigation if it ever comes to that. The form says that the seller client hereby advises the brokerages of the following, which may be latent defects or potential latent defects of listing the property, and consents that the brokerage disclosing the following to the other person, including cooperating brokerages or prospective buyers. And in that form, they have a list that is completed under the following heading: property structural defect, property systems defect, and property improvement defect. And they've got another section called others. I don't know what that is for. Now, when the form is presented to a seller by a listing agent, it appears that disclosure is required. This, however, according to a lawyer, is not supported by Ontario law. I'm going to repeat that. This is not supported by Ontario law, which was established by the Ontario Courts of Appeal in an actual court case back in 1979. Sellers are only required to disclose defects if they are actually aware of them, obviously, right? But if they are hidden, if they render the house structurally unsound, if they are so serious as to make the home unfit for habitation, and if the defects actually exist, none of these exceptions appear in the Form of 299. In creating the form, it appears that OREA has misinterpreted a regulation under the new Trust in Real Estate Service Act, which came into effect December of 2023. The regulation clearly states that a broker must disclose facts to any interesting parties if the seller has a legal obligation to disclose those facts. Based on the 1979 court case, sellers have no obligation to disclose defects or potential defects unless they meet all the exceptions in a court's decision. Now, Form 299 goes well beyond what a seller has to disclose under the Ontario law, and in my opinion, this form exposes everyone included in the transaction to needless and expensive litigation if it ever comes to that. The funny thing is, many realtors don't even know that this form exists. And seriously, would you as a seller sign a form like this? If you as a realtor put this form in front of your seller, they're going to freak out, because why on earth would they take ownership of a defect that they themselves cannot see and are completely unaware of? Well, you tell me what you think. And once again, thank you so much for watching. And if you found this information useful, please do not forget to subscribe and hit that like button. If you still don't know who I am, just go check my rating on Google and read my client reviews. Join me next week for more information on the market. Till then, you take care. And remember, don't forget to call me, because I hold the key that opens the door to your dream home.